case briefs, and so much more. LSData's got what you're looking for.
In a momentous 1998 case heard by the United States District Court for the Southern District of New York, a securities fraud lawsuit has led to a re-evaluation of the designation of lead plaintiffs in large class actions, initially filed under Section 21D, A, 3, B of the Securities and Exchange Act of 1934 and compounded by the Private Securities Litigation Reform Act of 1995. The lawsuit drew attention to a key requirement. The most adequate plaintiff is not only the one who files the complaint or motion, but also bears the largest financial interest in the class's relief. In the midst of these allegations, three entities emerged from the crowd: the Colorado Public Employees Retirement Association, known as ColPERA, the Vogel Group, a collection of private investors, and PBHG. Notwithstanding Vogel Group's lack of institutional investment backing, the court appointed each of these groups as co-lead plaintiffs due to the significant losses each had experienced. This marked decision solidified their standing by corroborating that the best interest of the proposed class is served by broad representation. In response, however, the court stalwartly noted potential conflicts of interest should ColPERA, as an institutional investor, provide direct funding to the case. It thus incorporated a system of checks and balances by assigning a single equal vote to each of the co-lead plaintiffs. This, the court deemed, would facilitate a fair sharing of resources and expertise and enable swift litigation against the defendant. In addition to the co-lead plaintiffs, the court assigned an executive committee of lawyers, each representing plaintiffs who suffered losses exceeding $450,000. As an extra measure of preemptive caution, the court established an Options Subclass but deferred the issue of appointing its lead plaintiff until pretrial discovery clearly demarcated the issues at trial. Adhering to a strict timeline, the court required the co-lead plaintiffs to file a consolidated amended complaint within a month, detailing facts supporting the broadest class period. Following this, a discovery and case management plan, subject to court approval, needed to be submitted within another month-long period. Meanwhile, pending motions were put on hold, but not altogether dismissed, leaving the door open for a potential renewal once the amended complaint stands filed.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.